Record in State of Ohio versus Marcus Braden. Court is on the record in State of Ohio versus Marcus Braden. Case number 24 CRB 394. On December 30th, 2024, Mr. Braden was convicted of one count of attempted breaking and entering, a first-degree misdemeanor. As part of the sentence, I suspended 180 days in jail. I placed Mr. Braden on 2 years of supervised community control, ordered him to perform 100 hours of community work service to be completed no later than June 30th, 2025. I imposed a $500 fine plus court costs to be paid no later than June 30th, 2025. I ordered the defendant to make restitution to the County at Elks Club in the sum of $401, and that restitution was to be completely paid at the County Municipal Court no later than June 30th, 2025. I ordered that he submit to a comprehensive...
Buckle up, guys. Today we're going to watch a judge lay out a full breakdown of a defendant's past decisions and the consequences that followed. From the very first words, the courtroom shifts into a no-nonsense tone as every detail of conviction, probation terms, fines, and deadlines laid bare. This opening sets the stage for everything that unfolds next, and the tension climbs immediately.
To a comprehensive diagnostic assessment at the Community Counseling Center for substance abuse and mental health purposes within 15 days to comply with any recommended course of treatment and execute any necessary releases. He was ordered to stay drug and alcohol free for 2 years. He was ordered to remain off the premises at the County at Elks Lodge. He was ordered to obtain and maintain employment. This case is set for a sentence compliance hearing, which I ordered scheduled after the June 30th deadlines that I've imposed as part of my sentence. Mr. Braden is present. He is without counsel. Also present is probation officer Sean Benoit. Officer Benoit, can you outline how Mr. Braden is doing?
Yes, Your Honor. He's completed the 100 hours of community work service. He completed that on 11 June 2025. He's still complying with the treatment recommendations of Community Counseling Center. He didn't miss his last two. One was supportive employment. Last one would be Tuesday, 15th of July of this year with Community Counseling Center. No payments on his fines or restitution. He still owes $401 to the Elks Club, Your Honor. And he's currently working as of approximately 2 weeks ago at Franco's Pizza.
I'm just noticing here that
in this segment, the probation officer steps in and delivers a mixed report. Some boxes are checked. Others are glaringly empty. The judge listens, clearly weighing every detail, especially the lack of financial compliance. When the defendant's written request for an extension surfaces, the energy pivots. You can sense the coming confrontation as the judge prepares to dig deeper.
Mr. Braden did submit something in writing, which is, I think it's the first time I've seen something. June 18th, 2025, more or less requesting an extension. And we'll address that today. So let's go back. He's completed the 100 hours of community work service, right?
Yes, Your Honor, as of 11 June 2025.
Okay. And he's receiving treatment at Community Counseling Center.
Yes, Your Honor.
What kind of treatment is he receiving? Do you know?
I'm not exactly sure what. They didn't send me the treatment plan, but they sent me a schedule and he has been compliant with their appointments.
So, Mr. Braden, you're receiving mental health treatment there at
Yes,
Community
Your Honor.
Counseling Center? Are you receiving substance abuse treatment?
I don't believe so, Your Honor.
I can't tell from what I have here, but it seems like you may just be receiving mental health treatment. What, Mr. Braden, are you doing with respect to employment? You're working at Franco's?
Currently, yes.
How long have you been working at Franco's?
2 weeks, Your Honor.
What employment have you had since I sentenced you on January 13th?
After your sentencing,
Here, the judge zeroes in on the treatment order, trying to determine whether the defendant is truly complying. The answers are vague, uncertain, and incomplete. Quickly, the discussion shifts to employment, marking the start of a more thorough examination. Every question from the bench feels increasingly pointed as the judge tries to get clarity the defendant struggles to provide.
I had taken employment in Geneva at the Green Bay Packaging Company.
At what was it called?
The Green Bay Packaging Company.
Yes.
I worked there for between 3 and 4 months, and then I got let go because I missed too many days. And then ever since then, I've just been trying to find the right one in between there. Had a couple jobs in between there. Until now, I just had a interview at the resource center 2 days ago for an opening there.
You had an interview at the Human Resource Center?
Yes, sir.
For what?
For it's maintenance assistant and food pantry assistant.
Do you have your GED?
Yes.
You remember your diploma, I should say.
Yes.
Well, help me understand. You have not made any payments toward restitution. None. In the last 5 months. I gave you February, March, April, May, June. I gave you 5.5 months to pay all fines and costs and to make restitution. And not one payment has been made. Help me understand why.
Your Honor, I haven't been able to accumulate any extra money to bring to the courthouse. Everything that I've been trying to save up just gets spread within my family. Trying to make
This section shows the defendant's job history slowly unraveling under scrutiny. Each position lasted only briefly. Each explanation raises more questions than answers, and the financial obligations remain untouched. As the judge presses for reasons, it becomes clear the defendant is struggling to stay afloat, but the excuses aren't lining up. The pressure in the room grows steadily.
ends meet.
How many hours a week are you working at Franco's?
Right now, it would be about 16.
Have you gone through like a temp service, like
Yes, sure.
Infinity or Elite or anything like that?
Elite.
And you mean to tell me they can't find you a job?
That's how I got my first initial job, Your Honor. And after that, they couldn't find me much more besides a few shifts that were too far out of my range.
Is it because you got terminated?
My first employment, yes, I did get terminated.
Well, that's what I mean. In Green Bay, you got terminated. Is that why they can't find you another job? Because you got terminated from Green Bay?
Well, it'd be the job after that. It was in Jefferson. Well, I've had 3 jobs. They just haven't worked out, Your Honor. Just whether it be.
Were you terminated all 3 jobs?
No.
You know,
The judge begins pushing harder now, asking about temp agencies and whether they've been able to place him in reliable work. The defendant's answers paint a picture of inconsistency and short stints that ended quickly. It's a turning point where you can see the judge's patience thinning, setting the stage for the sharper confrontation that's about to land.
You know, I'm pulling teeth here, Mr. Braden, and I don't like having to pull teeth and have to ask a million questions to get answers here. So you worked at Green Bay Packaging in Geneva for 3 to 4 months since this. You were terminated because you missed too many days. That's all I know. Fast forward to Franco's Pizza. So tell me where else you worked at before Franco's Pizza.
All right, Arthur Lewis Steel.
How long did you work there?
For 1 week.
Why are you no longer working there?
I had to miss work and they did not allow that on the first week. I had an appointment with my doctor and I couldn't get it done in time.
So you terminated.
Yes.
When's your next employment?
I was at King Luminaire, Jefferson.
How long did you work there?
2 days.
Why'd you leave after 2 days?
The hours were not working out with my family.
So you quit?
Yes.
Where'd you work after that?
Freckles Pizza Nut.
If it were me, I would have filed a probation violation against you. You had a felony charge dismissed, and you pled to a misdemeanor in this case. And I put you on...
This is where everything tightens. The judge calls it pulling teeth, and that phrase captures the entire tone of this exchange. Each job failure is dissected one by one, the reasons shifting but never fully solid. As the judge extracts details piece by piece, the disconnect between expectations and performance becomes undeniable, and the pressure on the defendant is unmistakable.
I put you on supervised probation with certain conditions, one of which was to obtain and maintain employment. Because you have financial responsibilities in this case to the victim whose business or locale you broke into to commit a theft. And to this court for fines and costs. I can't tell from what Officer Benoit has provided me whether there's any compliance. All these are, well, it says kept, CBT, I don't know what this means, CBC, DNS, I think that means did not show, CBC, DNS. You're having some meetings with supported employment at Community Counseling Center. They're there to help you find a job. How come the last 2 appointments you had on July 7th and July 10th with supported employment never happened?
Something came up, Your Honor.
You know, I don't want to hear it. What do you think, this is a game?
No.
Who's helping you find a job now? Elite? Infinity? Support employment? Who is there to help you provide assistance for you to find a job?
Here, the judge breaks into a blunt lecture, pointing out that a probation violation could have been filed. The gravity of the original charge is reiterated, and the expectations of employment and accountability are reinforced. When the missed appointments come up, the judge's frustration reaches a new level. Every sentence lands heavily, signaling that leniency is wearing thin.
My son supported employment.
And you don't show up for supported employment. Mr. Braden, let me make very clear to you. I am not a happy guy right now. You think you would have come here at your 6-month point based on what all that transpired in this case in January. You would think you would have came in here in full compliance with everything that I ordered you to do. And I'm not happy because it's not happening. So your letter asks for an extension. What kind of extension do you want me to give you?
I was looking for another 6 months, Your Honor.
Is he been coming to appointments?
Yes, Your Honor.
See, you did all your community service, the County Human Resource Center.
The tone escalates sharply as the judge calls out the defendant for treating the process like a game. It's a moment of raw judicial authority, reminding everyone of the stakes. The judge expected full compliance at the 6-month mark and makes it clear that the reality falls far short. As the discussion turns toward the extension request, the tension continues to rise.
Probably one good thing for you. You did all that. Why are you missing work that led you to be terminated at Green Bay?
My daughter, she had an extensive stay in Yankee.
When was she born?
April 10.
And what about Arthur Lewis Steele? You were there for a week. You missed work because you had to be at a mental health appointment?
Yes, sir. And I did not communicate that I had to leave to go to my pharmacy after that was. So, it didn't wait that.
And then at King Luminaire, you just didn't like the hours and you walked off the job after 2 days. We're really familiar with King Luminaire. We have a few of our participants in renewal court who are happily employed there. Any suggestions, officer?
In this segment, the defendant asks for more time, but the judge wants answers first. The explanations for missed work range from personal emergencies to scheduling issues, yet none fully satisfy the expectations placed on him. Each job failure is revisited with sharper focus. And by the end of the section, the judge turns to the probation officer for practical input.
No, Your Honor. My understanding wants to complete community work service in place of the $1,034 in outstanding court costs and fines. That would equal up to 94 community work service hours. He estimated 100 that he ordered to do so. Just the financial issues that he's facing due to his lack of employment.
Are you requesting to be able to perform community work service in lieu of your fines and costs?
Yes, Your Honor.
Well, that request, as required by law, is granted.
Thank you, Your Honor.
But you have to pay restitution.
Yes, sir.
You have to pay that. You can't do community work service in lieu of restitution. I'm ordering you to pay restitution in full by the end of September. September 30th. You have to pay the Connie Elks Club through this court $401 by the end of September. I will give you until...
The probation officer outlines a proposal for community service in place of fines, and the judge grants it, noting the law requires it. But restitution is non-negotiable, and the judge stresses that point firmly. The deadlines are set with precision, and the expectations are clear. This moment shifts from confrontation to structured consequence, tightening the path forward.
Until November 26th to perform community work service in lieu of fines and costs in this case. We're going to set a compliance hearing early December. And the obtain and maintain employment stays in effect. You must be employed. And you must, and look, I'm not being critical of Franco's Pizza, but a 16-hour-a-week job is not employment. I'm talking about full-time, gainful employment.
Yes, Your Honor.
So that's what I'm talking about. You must be employed by the time of the sentence compliance hearing. Fully employed. Did you understand everything I just told you?
Yes, Your Honor.
All of the other conditions, and I really want more.
Now the judge lays out the final framework: restitution by September, community service by November, and a December compliance hearing. Full-time employment is no longer a suggestion, but a requirement. The judge also demands clearer information from the counseling center, reinforcing that this case is being monitored closely. It's a turning point where accountability becomes absolute.
I really want more information from Community Counseling Center on whether he's being urine drug screened and what's going on with these. Anything further, officer?
No, Your Honor.
Okay, Mr. Braden, you'll go to the clerk's window. The officer will give you a hearing date for sometime in early December, and then we'll issue an order at some point in time. and we'll probably have to mail that to you.
The final clip brings a hearing to a close. The judge directs the defendant to the clerk's window, confirms that a new date will be issued, and wraps the proceeding with an unmistakable tone of authority. It's a quiet but firm ending to a tense session, reminding the defendant exactly what expected next.